All right.
My Lord, just one final paragraph in the case I was referring to before the choice of German. The Authorities, Volume 2, tab 28. It's at paragraph 157. Again, I only draw attention to it because it's a familiar argument, and indeed, with respect to my learned friend, one that he comes very close to. It says, Mr. Coulson in particular seemed to come close to submitting that once a transaction had been performed on both sides, as in the case of the design and construction of the store, it was too late for either of the parties to the transaction to contend that there had been no contract between them in relation to the transaction. Relying on Percy Trentham, which explains the problems of that case, and the learned judge says nothing in Percy Trentham is intended to get away from the traditional rules of offer and acceptance, and he says that at the end of that paragraph. There's one final case, my Lord, before I conclude, which was the decision of Mr. Justice Ramsey in Volume 1 of the Authorities in Hayden Young, tab 17. Obviously, Mr. Justice Ramsey is the current head of the TCC. Again, illustrates why this is a familiar problem in these types of contract. One has at paragraph 1 and 2 a brief description of the project. It was a completed project for a stadium. Paragraph 3, no subcontract document was ever signed by Lang O'Rourke and by Hayden Young, and a dispute has arisen as to the existence of a contract between them. And then, unsurprisingly, one says there is a contract, the other one says there isn't. There were, it's fair to say, detailed negotiations ongoing, so it's different to the present case. If your lordships go to paragraph 29, there was a point at which the parties had arrived at a set of subcontract documentation and requested that it be executed as a deed in the term within 7 days. And at paragraph 66, his lordship started on the question of whether a subcontract had been concluded.
Well, paragraph 30 is relevant, isn't it?
My Lord, yes. So there were detailed detailed discussions ongoing between these parties. It's not the same as in the present case, but the purpose of this is to illustrate from the judge in charge of the list why these are real issues. So when your lordships, if your lordships argument guidance, have to take into account the way they've approached it, which is fairly consistent. In 66, this case provides another example of an instance where the parties did not sign a subcontract, but where the subcontractor proceeded with the works and the contractor paid sums by reference to the terms of a draft subcontract. So same as in the present case. Hayden Young asserts that there is no contract because all essential terms were not agreed. Lang O'Rourke asserts that a contract came into existence, although there was no executed contract, because all essential terms were agreed. In 67, his lordship identified that by the end of the hearing, it had become apparent there were 4 main issues relating to the existence of a subcontract. The first issue related to the agreement of a limit of liability to be included in the warranties. The second related to the agreement of a limit on consequential losses. The third issue concerns Hayden Young's submission that there was no signed and executed form of subcontract, and that such an executed form of subcontract was necessary for an agreement to come into existence. And we don't need to look at the fourth. Contract formation and the law, his lordship sets out cases with which the lordships are now familiar. Panyan in paragraph 69, 71, Percy Trentham. And then in 73, his lordship subsequently adopts this passage from Keating, which is one way of expressing what I was rather inelegantly saying before the short adjournment, that the tools available to the court are aimed at what was said in Appellant to try and find the actual commercial objective, but it doesn't get away from traditional concepts of offer and acceptance. And Keating said, it's sometimes difficult to determine whether a concluded contract has come into existence when there have been lengthy negotiations between the parties, but no formal contract has ever been signed. It is suggested that a useful approach is to ask whether the following can be answered in the affirmative. In the relevant period of negotiation, did the parties intend to contract? At the time when they are alleged to have contracted, so at the time, had they agreed with sufficient certainty upon the terms which they then regarded as being required in order that a contract should come into existence? Did those terms include all the terms which, even though the parties did not realise it, were in fact essential to be agreed if the contract was to be legally enforceable and commercially workable? Was there a sufficient indication of acceptance by the offeree of the offer as then made, complying with any stipulation in the offer itself as to the manner of acceptance? So that's the form of contract, the execution point. On such an approach, the court's task is to review what the parties said and did, and from that material to infer whether the parties' objective intentions as expressed to each other were to enter into a mutually binding contract. And His Lordship then said, I consider that summary in this passage accurately reflects the approach set out in the authorities. So it's not just focusing on performance, it's looking at everything. And he then sets out the questions to be answered on that particular case. He then goes forward in paragraph 74 and says, in this case, it is evident from the documents and the oral evidence that the party intended to create legal relations. The main issues are, therefore, and then he sets them out, following what he's already said. At paragraph 122, he deals with, again, coming back to the point I was endeavouring to make about, in a performance-type case, the need for a very, very clear acceptance of the particular offer. It says, in order for Lang O'Rourke to establish there's been acceptance by conduct, it has to be clear that Lang O'Rourke acted with the intention of accepting the offer. And your Lordships may also remember that in the Mirrand case, which your Lordships have before you, it was emphasised by the Court of Appeal that it has to be an acceptance of the offer that is being made. So on my learned friend's case, the offer to contract on the basis of the technical specifications only, there being no evidence that that ever occurred, of course. He then sets out a passage from Yorkshire Water. Contractual acceptance has to be a final and unqualified expression of assent to the terms of the offer. Conduct will only amount to an acceptance of, it is clear that the offeree did the act in question with the intention of accepting the offer, but the test as to whether there has been such an agreement is an objective one. It follows that conduct which demonstrates an apparent intention to accept can be sufficient, despite uncommunicated mental reservations on the part of the offeree. However, it seems to me that for that situation to arise, the conduct in question must be clearly referable to the offer, and in the absence of knowledge of the offeree's reservations, not reasonably capable of being interpreted as anything other than acceptance. And of course, on the present case, there's never an offer put forward in the terms that my learned friend contends for on any view. And so one can't have acceptance of that as an offer. Different question, of course, arises in relation to the MF1 terms. In relation to the formation of the contract, paragraph 140, His Lordship cites the familiar passage from Lord Justice Lloyd, Panyan. Even if the parties have reached agreement on all the terms of the proposed contract, nevertheless, they may intend that the contract shall not become binding until some further condition has been fulfilled. He then sets out the Jarvis and Galliard case, your Lordships have seen. At paragraph 143, it says, in this case, therefore, the question must be whether, on the basis of the documents and the communications between the parties proceeded on the footing that there would be no contract unless and until there was a formal contract. He then turns to consider the relevant documents and communications, and it says, matters commenced when Lang O'Rourke first sent Hayden Young a proposed subcontract on the 17th of December. It requested Hayden Young to execute the subcontract as a deed and return 2 copies. Lang O'Rourke therefore envisaged that the subcontract would be in the form of an executed document. The same request was made when the revised documents were sent through to Hayden Young on the 10th of August. And then he sets out the rest of the facts in paragraph 151. I therefore conclude that on the basis of the documents and the communications between the parties proceeded on the footing that there would be no contract unless and until there was a formal signed executed contract. It was evidently the intention of both parties from the 17th of November to the 18th of August, 2 different years, that the subcontract would be formed by the signing and execution of the subcontract documentation. This did not happen, and therefore, in my judgment, there was in any event no concluded subcontract between the parties, even where there has been performance in anticipation of that contract being signed. And again, that comes back to the point in Galliard that one is looking for proceeding on the basis that if you have that sort of contractual arrangement or anticipated contractual arrangement, it will be given effect to. And in the present case, as your lordships have seen, it was Müller and Friends' positive case. There was no change after the 5th of July of 2005 to the intention that this should be a subject contract. So that really puts the focus for your lordships debate on that period 29th to the 5th of July in interpreting how the lordships come to the conclusion, if your lordships are with me on either of my cases. As I've said, it also explains in my submission why Lord Justice Waller was right in the penultimate paragraph of the judgment of the Court of Appeal to identify that if you are arguing a subject contract case and there has been a change somewhere along the line, you would need some kind of express variation, something very clear and unequivocal to show that there had been a different agreement reached, and there wasn't any in the facts of this case. And that seems to be common ground. Lord, I believe I've covered most of the arguments, indeed probably gone wider than many of the arguments, yes. Unless there are any other matters on which I can assist your lordships.
No, thank you very much. Mr. Manzoni? No. Yes, Mr. Manzoni.
May it please your lordships, I'd like to respond to a number of the points that my learned friend has made in the course of his address. Of course, if your lordships have any particular points you wish me to deal with, I will deal with them as and when the lordship wishes to raise them with me. But as my Lord Phillips said to Mr. Catchpole in the course of his address, this case is a rather extreme example of a case where we have performance of a contractual obligation, we say. And we also have the feature that by the 29th of June or the 5th of July, the parties had reached agreement on the specifications that the equipment was to fulfill. And they had also reached agreement, subject to the liquidated damages point, on the MF1 terms. Now, I'm going to address your lordships in due course about what the precise factual position was in relation to liquidated damages. And yesterday, my Lord Clerk asked about the witness statement evidence. You've seen almost all of that, but I'm going to make some further submissions about that. The parties performed this contract. They sat down in August and agreed a variation to take account of the fact that Müller wanted the lines installed in a different sequence than had been earlier set out. And at trial, it was common ground between the parties that the equipment that had been supplied was supplied in pursuance of some contractual obligation. It was common ground. Now, it wasn't common ground at trial how the contract was formed or what contract it was that gave rise to the parties' mutual obligations. But at trial, it was common ground that there was some contract or other pursuant to which this equipment was supplied. And no positive...
Which equipment? All the equipment?
All the equipment. Yes, because our learned friend's case was that the letter of intent contract applied throughout, and the equipment was supplied pursuant to that letter of intent contract, and price was paid pursuant to that. So that was their case. Our case was different, that the letter of intent contract did expire, but was replaced, in effect, by a subsequent contract based, as we have suggested, or we submitted to the trial judge, on specifications, without, of course, the limitations which appeared in MF1. Now, the Court of Appeal was right in our submission to record that at trial no side advocated no contract. And in our submission, the reason why they did that is plain. That where we have a scenario where the specification has been agreed, in effect, and the contract has been performed, it is in our submission an archetypal Trentum situation. So the consequence of there being no contract, my learned friend says, well, it doesn't matter to me whether there was a contract or not. Either we have a claim as a matter of quantum merit, and the extent of our liability is limited by the amount that has been paid, or we have a limitation pursuant to the contract of 1.682 million. Now, I know my Lord Clerk is interested in this question of quantum merit and how it potentially features in this case. And we have briefly set out in our case at paragraphs 79 to 82 some features of quantum merit which, while they may be acceptable from the perspective of the seller who has either been paid or partly paid, it does not offer an equality of protection as far as the buyer is concerned. Under the law of restitution, in order for Müller to recover any part of its purchase price, it would have to show a ground for restitution. There had been a total failure of consideration, if there had been a mistake. But the expectations that Müller has in relation to the equipment would not be protected, or at least would not obviously be protected under the law of restitution. Now, there are two learned articles which I don't propose to take your lordships to now. I just want to draw your lordship's attention to the fact.
This was in your case where?
This is in paragraph 79 to 82 of our case, which you'll find in a core bundle under the tab Appellant's case, at pages 24 to 25. Now, it's under the heading Consequences of Disregarding Performance. And as we submit in paragraph 81, the purchaser's position is significantly weaker if there's no contract. He has no claim for loss caused by defective or delayed performance. He has no claim for expectation loss. His sole possible recourse is to say that such matters ought to be taken into account in determining the quantum of any reasonable sum due to the seller, because he did not receive what he had requested. Whether such matters can, however, be taken into account remains shrouded in uncertainty. And the articles, there are two learned articles in this regard, which we refer to, and Mr. McKendrick, in Restitution Past, Present and Future. I'm not going to take your lordships to it, but it's in volume 3, tab 44. Mr. Headley's response at volume 3, tab 46. Now, the position that is being made there is simply that the law of contract protects expectations, whereas the law of restitution, it does not, or may not. And it is not an easy matter to determine the extent to which disappointed expectations can be protected under the law of restitution.
Well, what is the nature of your claim for 3 million? Because in theory, you could bring a claim in tort.
Yes.
And I was thinking of Tojo Maru, which is a classic case of quantum merit.
Our claim is formulated in contract. It's a contractual claim. But in theory, there could be a tortious claim, I suppose. Such a claim is...
What for? I'm not sure we've ever discovered what
No, we haven't.
went wrong with the yogurt.
Well,
If the yogurt was ruined...
Nothing went wrong with the yogurt, my
Yes.
lords. What did go wrong was that the robots started to throw the yogurt around, and they didn't function as they ought to have done, which meant that various losses were inflicted on Müller. They weren't able to save the cardboard, the many millions of pieces of cardboard they would otherwise have saved through repackaging these products into their line, and the losses were formulated essentially on a loss of labour, because the lines were supposed to be labour-saving devices. In fact, we weren't able to make the savings which we anticipated as a result of...
It doesn't sound like a talk player to me.
No, it doesn't sound much.
Loss of profit, not
indeed.
damage.
That's why I say there might be some difficulty in forcing these facts to fit the law of tort. But the point I was simply making, my lords, is this, that my learned friend says it doesn't matter to him whether you find a contract or not, but it does, as far as Müller is concerned, in relation to the possible protection or lack of protection for its expectations. Now,
Just before you go on, could I just like to ask a question arising out of the variation? The judge held that said in paragraph 106 that it was common ground that between the parties, that the contract between them was varied on the 25th of August.
Yes.
Now, what does that mean?
Well, what that means...
How is that consistent with the proposition that there's no contract?
Well, that's because, my lords, as I've said, it was common ground throughout that there was a contract. What wasn't common ground was how that contract came into existence. My learned friend's case was that there was a contract formed in March, which the learned judge found was the letter of intent contract. His case was that contract continued throughout and didn't expire. Our case was, as I said, different. Our case was the letter of intent contract had a finite life. It expired and was replaced by the subsequent contract which the learned judge found. So the learned judge is correct in recording that it was common ground that there was a contract which existed at that time, and it was common ground that that whatever contract existed at that date was varied in the manner in which the learned judge recorded.
And how is that consistent with the Court of Appeal's analysis of no contract?
It's not.
I don't agree with my own friend's analysis of the judgment, but I'll stop shortly. At that paragraph, his lordship has already determined there is a contract. So he's answering a sequence of preliminary issues on the basis that the contract that he has just found, it is common ground, has been varied.
Yes, but it was also...
So just on your case, though, what did happen then in August? What was the status of this contract? Quote, agreement, unquote.
This was an agreement to change the specification to which we've been working to, the test plan.
So it was a non-contractual contract?
Well, if it was the MF1 form, my lord, it would have taken effect as a variation of that. If it's a variation of the contract that my learned friend contends for, it's a variation of that contract. If there is no contract, it's a variation of the specification which amounts to the request from Müller to my clients. Because what they were concerned with was the way in which things were tested.
So it is it's an agreement which it doesn't have contractual effect.
That is one possibility if there is no contract. It's just
But that is your case if there's no contract.
Yes, and what my learned friend is right about is that the no contract argument was not, as the Court of Appeal say, developed in any detail certainly by us or by them. But it was clearly raised, and indeed you've seen His Lordship, Mr. Justice Clerk, raising it in argument with counsel.
But there's no document relating to the August the 25th variation, is there? At least the minutes of the meeting are not in the papers.
I'm afraid I wasn't involved in the trial at first instance. I don't know the detail of...
There seems to be something called the revised project plan.
I don't think there's any, I may be corrected, but I don't think there's any dispute as to what was agreed to be done. The consequences of that...
But there was no obligation to do it if there was no contract. Well, it was agreed to be done, but no obligation to do it, is that right?
It would simply be, if it was a quantum merit, it would just be a change to the request that has been made by Müller.
But there would be no obligation to carry it out.
No, but we did. So
no, but if you hadn't, your case is that, well, never mind, just one of those things. Yeah. I follow.
It's dealt with in the witness statements. Yeah.
But my lord, that's the consequence. That only arises if it's still the subject contract has its force, for the reasons I've explained.
I don't want to indulge in this court with going through the pleadings, but perhaps if I just give a reference to your lordships, to my learned friend's pleading in relation to the variation, which is in Appendix Part 1, Tab 6, page 89, where he says after having been warned of these matters, that's the problems which would be caused by switching the delivery of the various lines. It's in the particulars of claim, and it said that the defendant instructed the claimant to vary the contract, and then it goes on to say, in the premises the claimant remained obliged to provide equipment which could meet the specification, but was relieved from from providing equipment which at the time it was put into production or any time thereafter did in fact meet the specification. And that's the variation case that the learned judge dealt with in the preliminary issues. What was the effect of what was or was not said, the warnings given at the meeting on the 25th? And the learned judge's conclusion was that whatever was said, it didn't amount to, it didn't relieve RTS of the obligation to provide equipment when it actually worked when it was put into operation. So both sides' case at trial was there was a contract which was varied in August 2005. Now,
just refer to paragraph 10.
Sorry?
Well, sort of, but I mean both sides had alternative cases.
Yes, both sides had alternative cases, but the alternative cases did not involve the proposition that there was no contract between the parties, no positive case. That was the position at trial, and that is what the Court of Appeal recorded the position as being. Now, my learned friend said a bit about the importance of certainty in contracts and in building cases in particular. Actually, my Lord Clerk put his finger on it, if I may respectfully say so correctly. The only certainty that one can have in a case such as this is not to commence work before a contract has been signed. Because if you proceed with a transaction in the absence of a signed contract, whatever the contract says, you're always going to find yourself subject to an argument that the intentions of the parties have changed, that they have waived any reliance on a disclaimer to create legal relations, or they're otherwise subject to estoppel. Nothing that this court says can prevent those arguments from arising, and they arise by virtue of the nature of the beast, if I can put it that way. If you start work in the absence of a signed contract, these arguments will always arise, and nothing that your lordships say in relation to the facts of this case are going to alter that in my submission one iota. Now, one of the issues that my Lord Clerk has raised from time to time is the question of price, and my Lord has expressed some concern about where one finds the parties' agreement on the price. As I submitted to your lordships in opening, the price was agreed from an early date, and one finds that in the letter of intent. It's 1.682 million. Now, what happened thereafter is that the parties did not at any stage revisit the price. That remained constant throughout their relationship. And furthermore, one finds from the invoices which were sent by RTS to Müller, if one looks at volume 2 of 2, appendix 2 of 2, at tabs 57 and 63, is on page 1114 of the bundle behind tab 57, and one sees a sales invoice from RTS to Müller and the invoice date is the 30th of June 2005, and the demand is for 30% of the total contract value on delivery. And the amount of that 30% is 504,600. Now, it doesn't say there 1.682 million, but 504,600 is 30% of 1.682 million. And that was, it's common ground that that was paid. And if one turns to tab 63, one sees an invoice dated the 31st of October 2005, and that is a demand for 10% of the total contract value. And one sees more readily there that 10% is 168,200, which is 10% of 1.682 million. So there is no question, and it was paid, so there is no question that throughout the parties' relationship, the Lordships found it was a contractual one or not, they continued to proceed on the basis that the price was 1.682 million. And on that basis, we do submit that there was and is ample material for which the trial judge was entitled to infer that the parties had agreed a price of 1.682 million. Now, one of the questions which the court raised was where does one find the judge's findings on performance in relation to this case? And one finds that at paragraphs 53 to 62 of his judgment.
I'm just contemplating your statement that the parties had agreed a price.
Yes.
The parties were ad idem as to the price to be paid.
Yes.
But that doesn't necessarily mean that they had contractually bound themselves to accept that price.
No, indeed.
Just accepted it.
No, indeed. But what one is concerned here to identify, my lord, is whether there is material from which the court can properly infer that the parties objectively intended so to be bound. And in our submission, there is ample material from which the court could so conclude. After all, we have the position where the parties have agreed the specification.
Yes.
The parties have agreed the terms and conditions. And it's true the terms and conditions do make reference to a figure of 1.682 million, albeit in a slightly different context. The parties continue thereafter the parties had agreed in February what the price was, 1.682 million. It was never revisited. And the only reasonable inference in our submission that the court can draw from that is that continued to be the price agreed between the parties, as indeed is evidenced by the fact that subsequently invoices were sent and paid on the basis of demands in relation to 1.682 million. The judge's findings in relation to performance are set out at paragraphs 53 to 62. And at 120 to 124 of his judgment. So those are the passages in the judgment where he records the performance of the parties. Now, I have to say that, again, it was common ground that the performance which was being rendered in 2005 was being rendered pursuant to some contract. So it's not surprising in my submission that the judge didn't make any more detailed findings of fact in relation to this, given that the parties' common position was that there was a contract. If the position had been that one party or the other was making a positive case that there was not, then the findings of fact may have been more detailed. But that's the extent of it in those paragraphs. Now, one of the points that I wish to make relates to this issue about liquidated damages, and as to whether there was or was not a live issue in relation to liquidated damages. I made submissions to your lordships yesterday that there was an outstanding issue in relation to liquidated damages, namely that the extent of the remedy in relation to non-performance had not been finally settled, and the judge made a finding of fact in relation to that in paragraph 74 of his judgment. And that is, in our submission, the starting point. He said, although many of the schedules were agreed, several were not. In particular, it was not agreed what Schedule 6 would contain. The words in capitals set out in paragraph 48 represented a proposed but never agreed refinement to give Müller some ampler remedy than liquidated damages if the performance of the equipment was lower than that degree of non-performance, which would give rise to the maximum liquidated damages. And that's the finding the judge made. So that, in our submission, is the starting point. But the important point is this, that if one takes the fourth draft of the contract, which is in bundle 1 of 2, appendix part 2, 1 of 2, and one turns to page 773 of the bundle, one sees that immediately this question that arises out of Schedule 6 isn't confined to Schedule 6. It impacts on Clause 5 of the contract, because if one sees on 773, one sees percentage of contract price to be paid to the purchaser or deducted from the contract price, and then in square brackets to be calculated in accordance with Schedule 6. So it immediately impacts on Clause 5, and it impacts on Clause 27.7, which is the clause in this contract, in this draft contract, which contains the material about the purchaser's rights and remedies. So it's not right to say that it has simply impact on Schedule 6. It has impact on Clause 5 and in relation to 27.7. And the fact is that remained the position throughout, as the learned judge was entitled to hold.
What is the Schedule 6 addition?
Schedule 6 is that wording, my lord, that you have
Yes,
seen.
but what's it got to do with the passage in Clause 5 that you read?
Well, what it's got to do with the passage in Clause 5 is that Mr. Morris is proposing some ampler remedy, as the judge found, in relation to performance tests. Now, Clause 27.7 is performance tests. as is indicated in clause 5 of the draft contract. And if one looks forward to clause 27.7, one sees provision for what happens if the works fail to pass the performance tests.
But the point I'm making is that Mr. Morris, is it?
Yes, Mr.
Morris's capital letters addition has nothing to do with the percentage of the contract price to be paid to the purchaser, or nothing to do with the definition of that.
Well,
what one would expect under 27.7 is to find in clause in Schedule 6 some percentage to be calculated in accordance with Schedule 6. And
yes,
I don't see that Mr. Morris's addition is giving me the answer to that.
well, I can't pretend that it gives the answer, but what I'm submitting is that what it does is raise an issue in relation to this point which has not and was not resolved, as the judge recorded in paragraph 74 of his judgment.
Mr. Morris's addition seems to assume that the percentage is agreed, which it is, I think, isn't it? I mean, looking at the original clause 6, it's 90%, 95% availability. And I
yes.
think that's been replaced by something else which probably has some percentages
Yes.
in it as well.
Indeed.
Yes.
But
So Mr. Morris's addition is saying what?
Well,
that if the test is within that percentage, within a certain percentage of the required level, what does that mean? Within a certain percentage of 95%?
well, it's within a whatever level is set out in the performance tests. That's what it seems to be saying. But if it's worse than that, then other remedies will be available. And that point, that was never finally satisfied. It was never dealt with by the parties.
Yes, if the percentage achieved is lower than that specified by liquidated damages,
Yes.
i.e. lower than the maximum payout under liquidated damages.
Yes. So
It never can be, because it never can be lower than the maximum payout under liquidated damages, because we know that the maximum is a minimum.
well, the drafting leaves something to be desired.
I mean, I'm not surprised that the parties didn't give any more attention to this, because frankly, it's nonsense. It just doesn't make sense, this clause.
The drafting leaves something to be desired. I accept that, but that's not the point. The point is,
If it's meaningless, it's meaningless.
well,
I mean, you think that somebody would have come back to it if it was a real point,
yes. Well, the learned judge seemed to think.
whatever the judge thought.
Well, the learned judge, rightly in our submission, came to the conclusion that this was, as he put it, proposed but never agreed refinement to give Müller some ampler remedy than liquidated damages if the performance of the equipment was lower than that degree of non-performance, which would give rise to maximum liquidated damages. Now, that's what the learned judge understood Mr. Morris to be proposing.
As I read it, he's proposing a fundamentally different approach altogether, because there's going to be quantification of the degree of shortfall.
Yes.
And a two-stage approach, down to a certain level of shortfall. You have the liquidated damages, and below that you have something better from your client's point of view.
That's right.
So that was his idea.
Yes.
But the evidence suggests that this was really floated internally and then abandoned.
Well, it's not right to suggest that it was only floated internally. And if one looks at the witness statements at trial, one sees what Mr. Morris's unchallenged evidence was about this. If one takes the bundle of trial witness statements and looks at tab...
I thought we were looking at the transcript as well, are we?
Well, we look at the transcript as well, my lord.
Yes, right.
But if one looks at... the trial witness statements, tab 2, at page 36, one sees at paragraph 35 and 36 the evidence that he gave in relation to this. So he says that he met with Mr. St John, who's an employee of Müller, on the 11th of July, and he wanted to take the contract to RTS. At our meeting, a number of outstanding points were identified which required finalisation. And he identifies what those were. There's the full address of RTS PLC, which may not be terribly significant. And then there is the way in which the liquidated damages provisions interrelated with the passing of the performance testing. This remained outstanding, despite my flagging the issue to both RTS and Müller commercial teams in my email dated the 11th of May 2005. Now, the Lordships have that email at Appendix Part 2, 1 of 2, at page 721 of that bundle, under tab 39. And what you've got at that tab is a covering email from Mr. Morris to, amongst others, Mr. Croquette, Mr. Bradford and Mr. Brown of RTS. And he says in the second main paragraph of that email, I note that currently Schedule 6 does not sufficiently deal with how liquidated damages will apply where a performance standard is not met or what will constitute failure of the test. And he says, I intend completing a suggested draft on this in the next couple of days. I'm also still considering your suggestions in relation to force majeure and will revert to you. And if one turns to page 748 of this bundle, this is draft 3 of the contract, and at 748 is the second page of Schedule 6, which contains this wording. So it isn't, and that appeared there for the first time in this draft. So it isn't correct to say that this was just something that was floated internally. It was referred to the commercial teams, as Mr. Morris says in his witness statement, and he flagged that issue up, and that issue was, as the judge held, never resolved.
It wasn't flagged up on the 5th of July.
Wasn't flagged up on the 5th of July.
And if the documentation had been signed in this form shortly after the 5th of July, an agreement to agree on a non-essential term wouldn't have made a difference.
Certainly a non-essential term would have made no difference. That is probably correct. Yes. As I say, the issue, according to the judge, in fact, was never resolved. But if one takes my Lord Collins's point, the conclusion one reaches is not that liquidated damages in terms of clause 27.7, but rather clause 27.7 itself was not agreed. And the question then one would ask, is clause 27.7 an essential term?
I mean, the irony is that at a later stage in the proceedings, you're presumably going to be arguing that these aren't liquidated damages which bind you at all, they're a penalty.
Yes, well, my learned...
So that they're invalid, so this is a wish to amend something which, in your favour, which isn't against you.
I wouldn't say it was a wish to amend something in my favour. I mean, as far as the MF1 is concerned, and my submissions are that the judge was right to conclude that as far as the LDs are concerned, it wasn't finally agreed. And your lordships have got the basis on which I say the judge was correct on the evidence, so to conclude. Now, the alternatives one could...
You haven't proposed any actual meaning, though, have you, for this?
Well, the
coherent meaning.
It is flagging an issue for the commercial teams to resolve.
Yeah. Okay.
Yes. I mean, I am not suggesting that when one reads what he has drafted, that somehow is to be given contractual force. That's not what I'm suggesting. What I'm suggesting is that when one reads that...
Yeah, that's no good at all. You wouldn't want that at all.
Well,
the whole point of your argument is that there were bits not yet agreed. So.
What I'm suggesting is, as the judge found, the LDs were not agreed because they were in search of a more ample remedy. And the basis for them having come to that conclusion isn't simply Schedule 6, it's the witness evidence of Mr. Morris, which wasn't challenged, and it's the documents which show that there was a continuing issue in relation to a more ample remedy in relation to liquidated damages. Now,
that message at 721.
yes,
I note that Schedule 6 does not sufficiently deal with liquidated damages or how they will apply where a performance standard is not met, or what will constitute failure of the test.
yes.
And but doesn't Schedule 6 tell us what will be failure of the test?
Yes, I think it does. But
yeah. I know he wanted a better clause.
He obviously did want it.
Yes.
And I mean, I'm struggling to do anything more than say what Mr. Morris identified as the problem, and what the judge identified as an outstanding issue. And what I'm saying is the judge was right to identify that as an outstanding issue for the reasons that he gave.
But what happened after that? What's the last... we're going to have... What was the date of the last document you looked at?
The fourth draft was the 16th of May.
So when he sent on the 16th of May, when Mr. Morris sent the document where he said, please find attached contract with final tweaks.
Yes.
That document itself contained the capital letters,
It did. That's right. And you see that at page 796. This is the fourth draft. Schedule 6 hasn't changed.
Well, it has, hasn't it? Because we
I'm sorry,
know that
I'm sorry, my lord.
the actual test plan is replaced on
I'm
the
sorry.
29th of June.
Yes, I withdraw that. What I mean is, when one looks at 1.4, this uppercase language remains there.
Well, possibly. I mean, one view is that the test plan replaces it all, but
the test plan doesn't replace it all, my lord, because one has to go back to clause 5 on page 773, which is dealing with performance tests, which is referable to Schedule 6, which continues to contain this language. Yes. And the evidence of Mr. Morris that I've shown your lordships in the trial witness statements is dealing with the position as it existed on the 11th of July, where he says there was still this outstanding issue which he had flagged up on the 11th of May.
And is there an 11th of July document that shows that?
Well, there is, yes. Yes, it should have been handed up this morning. It was handed up this morning. It's a loose leaf document, for which I apologise for yet more paper. I'm very sorry, my lords, there is an inordinate amount of paper. It looks like this. It has Gavin Brown at rtsgroup.com written on the front of it.
Yes.
Now, this was handed over. Well, I'm going to...
So what's this document? Is there any evidence about this document?
Yes, there is evidence about it, and I will refer your lordships to it. You lordships see what Mr. Morris says in his witness statement, that on the 11th of July, he wanted Mr. St. John to take the contract to RTS with him. This is what he says in paragraph 35 to his meeting. And in the evidence of Mr. St. John, which you'll find at tab 85 in the transcripts bundle, at page 101. You will see evidence given by Mr. St. John in chief, and at line 12 I asked him some questions about meeting RTS in mid-July, and he explains, I was going up to Erlam on one of my regular visits to see progress of the lines and discuss the project, and Will passed me a bundle to take with me to give to Gavin, that's Mr. Brown. When you say Will passed you a bundle, who do you mean by Will? Sorry, Mr. Morris. And what did that bundle consist of? It was a draft contract. Did you do anything with it? I handed it over to Mr. Brown, and did he retain it? I certainly didn't return with it. And then Mr. Manzoni cross-examined him. Just on that point, when you say a bundle, as I understand it, it was a bundle which essentially contained the draft contract conditions, but it didn't contain all the schedules, is that correct? I couldn't comment on what was in the bundle. I know it was the draft that had been discussed with Will. It was just an envelope, was it? No, it was an A4 Lever Arch file, but you didn't look in it. No, it didn't. Just give me an idea of what sort of thickness of it. Let's have a look at what I think it is, just so that we're absolutely clear. And then Mr. Justice Christopher Clark said something. And then Mr. Manzoni says, would you turn to call bundle 3, please? And in that, could you turn to tab 19, page 1 of tab 19? And if you look at that file, there are some green pages. Go to the first green page, which you will see is just after page 42. Was it something of this sort of nature? And he says it would have been yes. Now, page 19, tab 19, page 1, is the document that your lordships were handed this morning. This comes from tab 19 of the trial bundle, bundle 19, page 1. And some evidence about this was given by Mr. Brown as well.
Is this the latest version? Where is the latest version in the bundle before this? Or the
latest version of the bundle before this was, as I was just showing in front of this bundle, sorry? Part 1 of 2 at tab 41. So, if one looks at this document, which was explored with Mr.
Sorry, this is not the document that anyone said was the document handed over in this meeting. It was like this, and this is a copy of the fourth draft, exact copy of the fourth draft sent through on the 16th of May, containing the same wording in Schedule 6, and it was actually used for the meeting in November and contains Mr. Brown's annotations for the meeting in November, including reference to the subject. And as the cross-examination showed, no one could establish what document Mr. St John thought he handed over to Mr. Brown. Well, it was like this.
The evidence, I can't improve on the evidence. I'm not going to give evidence about what the evidence said, but I've shown your lordships what Mr. St John
Sorry, just
said.
refer me to the page in the transcript once again.
Sorry, it is at page 102. Sorry, page 101.
Yes.
And one bears in mind that one has had the evidence from Mr. Morris.
Has he given oral evidence somewhere
Mr. Morris did give oral evidence, yes.
on this point? Where is that?
On this point, I'm not sure. Yes, he was cross-examined on paragraphs 35 and 36, and I'll give you the reference to that. Yes, at tab 86. Page 30. Line 17 on page 30. Mr. Manzoni says, in terms of ignore for a moment the schedules, but in terms of the actual conditions, as far as you're concerned, apart from one or two very small points, those were essentially completed at around this time. And Mr. Morris says, again, I think from the documents, there were still one or two outstanding issues, not least the name of RTS PLC company, which to guarantee the obligations. From memory, I think the issue of the way in which the conditions relating to performance tests then related to the schedules are also outstanding, so there's still some important elements that are outstanding. And then Mr. Manzoni says, I think in fact you identify those in your paragraph 35. You identify three outstanding issues. It's page 36 of the bundle. And he says, the first is a full address.
Bit of a leading question. Please.
He's cross-examined, my lord, so he's...
Is he cross-examining, is he?
So he's,
sorry.
So he's committed.
Yeah.
And then he says, Mr. Manzoni says, the second is exactly as you've just identified, the way in which the liquidated damages provision is integrated with the passing of performance testing. That's essentially the point that's in capitals in Schedule 6, isn't it? And he says, yes, it is. So, Mr. Morris's evidence was that there was this outstanding issue in July in relation to Schedule 6, which continued to be outstanding. Mr. St John explained that Mr. Morris gave him a contract to hand over. And Mr. St John was cross-examined in relation to this. And Mr. Brown said that at page 80, at tab 85, page 6, and this is my cross-examination of Mr. Brown.
Sorry, which page are you on now?
Page 6, under tab 85, my lord. Then we turn to events in November 2005. And I say, it's right, isn't it, Mr. Brown, that sometime before the meeting you handed to Mr. St John of Müller an annotated draft of the contract marked up with your manuscript comments. That's correct, and I think we can see that at bundle D19. Can you confirm that this is the document? Which one? D19, page 1. No, that's not the annotated document I handed Mick St John prior to that meeting, I see. And Mr. Justice Christopher Clark says, do you recognise the handwriting? He says, I recognise the handwriting. Whose handwriting is it? That's mine with some comments by others. I'm just checking that now. I'm sorry, that's my mistake. That is the one I handed him prior to the meeting. I said, good. There is one other handwriting on it, which I think is Will Morris's. I'm just asking you to identify that as the document you handed to Mr. St. John prior to the meeting on the 18th, because that's what your solicitors told us correct. That's correct. The draft you annotated was pretty much a final draft of the contract, isn't it? And he says yes. And I think it's right, isn't it, that that draft had been handed to you by Mr. St. John earlier in the year in July. That's right, isn't it? And he says, I can't recall him handing it to me in July, right? I recall him discussing with me sometime in early November that there was a request from Will Morris that we now sign the contract, and I recall discussing with Mick there would be some difficulty at that stage given the actions of both parties were contrary to some of the provisions of the contract. And I made some very brief notes as to where I felt principal issues would be and handed that back to Mick. I can't recall getting that document in July. I think we got it prior to the discussions at the end of October, early November. And I say, but it's entirely possible, isn't it, that a draft was given to you in mid-July by Mr. St. John. That's entirely possible, isn't it? And he says it's possible because I can't recall whether I did or did not, so it's a possibility. Now, what is important is, as far as this draft is...
Well, we all know that anything's possible.
Anything's possible. But leaving aside whether your lordships are satisfied that through this process of examination, through the witness statements, one has established that this was the document which was handed over. Mr. Brown accepted in his cross-examination that this was pretty much a final draft. And the point I'm making is that when one looks at this pretty much final draft as he accepted, whether it was handed over in July or not, one sees that on page 22 it continues to retain the offending wording, if I can put it that way, in relation to Schedule 6.
Well, there's never been a version without that wording.
That's correct. Since the third draft onwards, your lordship's right. Your lordships may think I'm labouring the point. I am endeavouring to show your lordships, having asked me what's the basis for the judge's finding of fact. This is what the judge found. We say the judge was right to find what he did, and it would be wrong for this court to interfere with that finding of fact. Now, what consequences flow from that, if I'm right, is that 27.7, we say, is effectively not agreed, because the parties, Mr. Morris had raised in May this issue about a more ample remedy, and the parties had not resolved that. And we say the consequence of that is that clause 27.7 doesn't form part of the contract as part of MF1.
Could you just continue, just point out the last there, which is...
Yes. My learned friend asked me for your lordships to read tab 85, continuing on from where I stopped, over to page 9, line 14.
Sorry, where are we reading? Page?
Tab 85 of the transcripts bundle, page 8.
Yes.
I think from...
This is about letting Stephen double slide.
Yes,
Well, this passage, my lord, that follows where my learned friend stops, which says, we did not have any discussions around that time. My learned friend asked whether they had discussions in July. And he then goes, Mr. Brown says, my recollection at the time is the discussion on signing the contract had in fact gone quiet. The last correspondence I had was with Will Morris just around the final key points. And then I was expecting the schedules would be compiled formally, and that was around mid-July, and it went quiet at that stage. Question, it takes two to tango. Are you saying that you simply allowed it to go quiet in July as well? Yes, I think we did. It was Muller's contract. They were responsible for drafting it. I couldn't draft their contract for them. All I could do is service their request for information, and in fact service their request to sign it off if that ever came. I don't believe it came. I certainly do not recall getting this contract in a form where I could sign it, with all the schedules complete and attached, particularly with schedules 5 and 6 replaced by our test plan. And that then leads into the sleeping dog's life. So his evidence in relation to Mr. St. John is he didn't remember receiving that document from Mr. John. He had no discussions with him, wasn't challenged, he had no discussions with him, and that he was waiting for a formal contract which he never received from them.
Now, It's right I should say something about this question of subject contract. Clause 48.
Could I just ask this? The parties have the benefit of live note, I understand.
Yes.
And if anybody writing a judgment in this case got in a muddle as to precisely what had been submitted, live note might be of some assistance. So I wonder if we could have copies of the
I'm sure we can arrange that for your lordships.
of the transcript. Thank you.
Now, subject contract. Sorry, my lord.
We seem to be focusing very much on this Schedule 6 as to whether really there was anything unresolved, and I'm still a bit puzzled about the answer given to the judge about this at page 35.
So you're looking at the transcripts.
Transcript 86, page 35.
Yes.
Kind of line 15. I can't quite understand what it was you were seeking to achieve. Answer. As I recall, it wasn't at all clear the way in which the performance test, and if you like, the result of running that performance test would then have the liquidated damages provisions applying to it, right? Then this was my suggestion, I think, probably to my own team, that I acknowledge in a document that was externally, as to how I imagined that would work. But I wasn't party to the agreement as to what those liquidated damages were and how they were to be applied.
Yes, I think that your lordship sees that from his reference in his witness statement. He was flagging up an issue for what he thought the commercial. He's the solicitor.
Yes.
He's flagging up an issue that he would like the commercial teams to resolve.
Yes.
You see that from the email that he sends in May. And you see that from his witness evidence that he was flagging this up for the commercial teams to resolve. It's not right that it was simply internal, because as we see, this goes back and forward between RTS and Müller. But precisely what
And presumably would still be in any contract, for good or ill.
Well, your lordship's right that issue, as the judge says, was not resolved. What precisely he was seeking to achieve, I can't improve on what he said. And his evidence was, as the judge accepted, he was seeking to achieve something, a fuller remedy in the event of non-compliance with the performance standards in clause 27.7. And on our submission, that is evidence which the judge was entitled to accept, and to conclude that as far as that particular issue was concerned, that wasn't resolved. So we say the consequence of that is that represents clause 27.7 as reflected in clause 5 of the contract. Clause 27 of the contract represents an unresolved, an unagreed issue, and that therefore, as far as the liquidated damages element is concerned, that was not agreed, and therefore does not form part of any contract that the court concludes was made between the parties.
Yes.
Now,
so that would only affect the 27 the existence or inclusion of clause 27.7.
Yes.
Would it?
And 5, obviously, which it goes back to clause 5. It starts in clause 5.
Affects their counterclaim. Their counterclaim is for failure to perform. So that's why my learned friend arguing.
It starts in terms of the way in which the contractual documents work. It starts at this point. It starts at clause 5 and works through to clause 27. It doesn't just begin and end in Schedule 6. Now, as far as clause 48 is concerned of this contract, my submissions are that this is not a subject contract clause, clause 48, and I've already made my submissions at the beginning on that. And I
I think part of the point, though, is that whatever clause 48 says, the whole of this negotiation was subject to contract. That the whole of the the whole of these debates were subject to contract.
Well,
it always was an underpinning of the whole thing was that there was going to be an agreement, and that would be the agreement.
Yes.
So the whole thing was subject to contract. That's their point.
Yes, I have to accept that, as your lordships have seen from the submissions I made, we submitted that in effect these negotiations were being treated as subject to contract. We did not rely on clause 48. This was a clause which the judge fastened on. Now, he didn't say it was a subject to contract clause in his judgment, nor did he say in his judgment that I was correct that these negotiations were being conducted subject to contract. He didn't make such a finding in his judgment. So,
but if the whole thing, if all these negotiations were subject to contracts, including presumably the negotiations in relation to the schedules, then why is there a contract?
Well, you're absolutely right. I mean, I have to put my hand up in relation to the perhaps inconsistency in the submissions which I was making to the learned judge. I mean, one often embarrassed years later.
But anybody can make alternative submissions. I wasn't there, but if I was, I didn't do it.
Yes, but the submission I was making to the learned judge was not MF1, and the learned judge accepted that for the reasons that he gave. But I was obviously not submitting that there was no contract. So, because that neither side was positively asserting that there was no contract. My submission was that there obviously was a contract as a result of the parties having agreed the specification and having performed in accordance with that specification. Now, I accept that where the learned judge actually got to in terms of identifying the terms and conditions having been agreed, they were all agreed apart from, in my case, the liquidated damages. But as I say, the learned judge did not find that these negotiations were all conducted subject to contract.
No, but they obviously were.
Well,
weren't they?
The important point is, in my submission, that these negotiations were conducted in such a way that the parties expected the draft contract to be signed. It's not the same thing as saying these negotiations are being conducted subject to contract. The draft terms were agreed, and the parties got on with performance. They executed this contract, and they agreed a variation to it in August. So in those circumstances, the learned judge was perfect.
Well, they didn't execute the contract.
Well, the contract was executed. Yes, it was performed.
Performed.
Yes. So in those circumstances, the learned judge was entitled to conclude that it was not right that the parties did not intend to create legal relations. Indeed, he concluded to the contrary. So, yes, I put my hand up to having submitted what I submitted at trial, but actually, that isn't what the judge accepted. And in my submission, he was right not to accept that. My learned friend, Mr. Feely, reminds me of 2 points. First, that's right, I should address the order first before I address those minor points. My learned friend has given you 2 draft orders. The appeal dismissed with no consequential provisions. It requires no further comment from me other than to say I urge your lordships not to adopt that course. The other draft order does require some comment. The first paragraph suggests that even if your lordships find that there was a contract...
You say should say that he'll be allowed.
Yes, it should. But it doesn't stop there, because he invites the trial, this court, to send back a number of preliminary issues, effectively to the trial judge for retrial. And perhaps one should just pull out the order that the learned judge made in relation to the various issues, which your lordships find at tab 3 of the bundle. Sorry, core bundle, appendix 1, part 1, page 26. Now,
Say it again.
appendix, part 1,
Page 26.
tab 3, page 26. One sees the answers of the learned judge to the various questions that he was asked from page 28 onwards. Now, my learned friend's draft order suggests that preliminary issues 1.2.2 to 1.2.5 inclusive and 1.3 are to be determined by the trial judge on the basis of the contract as formed by the documents which he say are identified in paragraph 2 above. Sorry? I'm sorry, Mr. Feely has finally got through to me that it's paragraph 3 of the draft order I should be referring your lordships to. You may have already got there, and I'm sorry if I skipped the reason. Now, if one goes back, and perhaps before I make my submissions, it is important to realise that at trial, the rival contentions were, in relation to the contract, either the standard terms of RTS or the MF1 terms or some other terms. But the trial was being conducted on the basis that the answers that the learned judge gave it didn't matter which terms and conditions were applicable. So, for example, take the answer, take issue 1.3. This is on page 33 of the bundle. What are the terms of the variation agreed by the claimant and the defendant in August 2005? That is reflected in the learned judge's judgment and is dependent on the evidence which was given at trial by the witnesses. So we had to establish what was or was not said at the trial. And what was the effect of that in relation to the various performance criteria, which it was common ground the equipment had to meet. So it cannot be right that if your lordships are persuaded that there was a contract and say it was on MF1 terms, that there would have to be a retrial of the issue of variation, which the learned judge has already determined that simply doesn't arise. Because there has been a trial, and it was conducted on the basis that it didn't matter which terms and conditions applied as far as the variation is concerned. It simply didn't matter. Now, that's the most obvious example of why...
So if there were, if the court were to hold that there was a contract,
yes,
and that it was on all the MFI terms, you would like,
yes,
the documents that had been... suppose the court were to hold that the parties had in effect reached agreement on the basis of the documentation available to the parties on the 5th of July.
Yes.
I know that's not your case, but suppose that's what happened.
yes,
Then the question would arise what the appropriate order
yes.
would be.
I'm just wondering whether it wouldn't be better to cross this bridge when we come to it.
Yes, my lord.
Try and do it in anticipation. If we
Yes.
give the parties a chance to consider
Yes.
the effect of
Yes.
our judgment. And
Yes, certainly, my lord. I was going then to make two further points. And where's the paragraph now? There is an error in our statement of case, which I wish to correct, which I don't think materially affects the way the argument has gone. It is this, that I think we suggested that drafts 1, 2 and 3 were not in evidence at trial. Your Lordships have seen through my learned friend's coloured document the progression from 1, 2 and 3. In fact, we were wrong when we said that wasn't in evidence at trial because Mr. Morris, I think, refers to it in his witness statement. I wanted to make that correction as far as I've lost my reference, my Lord. 104. 104, my Lord, in our statement of case. It's not correct to say that the court, yeah, it's the sentence.
What, the appellant's case?
Yes, it's in the appellant's case. At paragraph 104.
We would just take out the draft documents,
Yes.
etc. Will not do sentence.
Yes, strike that.
Well, strike out the not. That's the easiest thing to
Yes.
strike out.
Finally, I believe I should raise the issue of costs with your Lordship. I didn't say anything about this in opening, and I haven't actually discussed it with my learned friend, but my submission would be that we should reserve for submissions in writing any consequential costs as a result of your Lordship's order.
That sounds very sensible.
I wish to make that point before I cite that.
I agree, my Lord. May I indicate, although it may be unusual before your Lordships, costs, consequences may be sufficiently complicated after discussions where one party or other may request a hearing unusually before your Lordships, but in principle I agree they should be reserved until we see what your Lordships determine.
Could I finally ask you one thing? Is there a document which has a dramatis personae on one sheet of paper anywhere? If there isn't, would it be possible to provide one so that it's quite clear who's who?
Yes.
Thank you very much.
We'll do. Otherwise, those are my submissions.
The court is grateful for counsel's submissions and will reserve its judgment.